My name is Katrina Scott. I am the academic director at the Center for Research and Education on Violence Against Women and Children at Western University, and I would like to welcome you to today's webinar on preventing intimate partner homicide, reflections from members of the Domestic Violence Death Review Committee, Part 2. This webinar is brought to you by three of CREVAC's projects, and we did that because we really wanted to bring this to as large an audience as possible. The Learning Network and Knowledge Hub are two projects hosted by the Center and who are proud to organize and co-host this webinar series. The Learning Network is a knowledge mobilization initiative funded by the Government of Ontario that bridges the gap between current gender-based violence research, practice-based knowledge, and lived experience, aiming to strengthen the capacity of the gender-based violence sector and movement. The Knowledge Hub facilitates a trauma and violence-informed community of practice for projects conducting intervention programming and research for people who've experienced family violence. This project is funded by the Public Health Agency of Canada. To learn more about the Learning Network or the Knowledge Hub, please access the website links posted in the chat. This webinar is also being co-hosted and shared through the Awareness to Action project in CREVAC's Family Violence Family Law area. This work is funded by the Department of Justice Canada and aims to increase the capacity of family law professionals to better recognize, assess, and address the impact of abuse in family court, and to improve the experiences of adult and child victims of family violence. Once again, you can learn more by accessing the link in the chat. Before we welcome the speakers, I would like to begin with a land acknowledgement. I want to acknowledge that our work is located on the traditional lands of the Anishinaabeg, Haudenosaunee, Lenapehoak, and Shnong-Tong nations. These lands are connected with the London Township and Songbird Treaties of 1796 and the Dish with One Spoon Covenant Wampum. Today, this land continues to be home to many Indigenous peoples from across Turtle Island. Of course, making a land acknowledgement needs to be more than a statement. It also needs to be a commitment to action. And especially now, during the 16 days of activism against gender-based violence, we're called to honor the memory of missing and murdered Indigenous women, girls, and Two-Spirit people, to read reports and recommendations by Indigenous colleagues and communities, and take recommended actions to challenge systems of oppression, including racism, sexism, and colonialism, that perpetuate violence on this land, as well as to support Indigenous-led initiatives that work to restore safety, sovereignty, and justice for all people. And this action applies to the DVDRC as well. As I will introduce in a minute, today's session will cover 3 chapters of the recently published report from the Domestic Violence Death Review Committee. The current report does not include a chapter focused on domestic homicide that involve Indigenous victims. This work is being done, though. Right now, there is a subcommittee working and a chapter being prepared that specifically examines the risk factors for domestic homicide involving Indigenous victims and will make calls and recommendations for change. We look forward to hosting another webinar featuring this chapter when it's released. I would also like to begin this webinar by honoring the victims, their family members, their friends, their colleagues, and all of those affected by domestic homicide. You know, it's really a great honor and a pleasure to serve on the DVDRC and to try to think about ways to prevent these kinds of deaths in the future. But in doing this work, there's no way to not be so profoundly impacted by the losses experienced by the families, by the individuals, by the communities. And so this website is this webinar is really dedicated to their memory, and the work of the Domestic Violence Death Review Committee is dedicated to trying to make sure we do everything possible to prevent such homicides in the future. And in this webinar, presenters are going to be sharing some real life case examples and information about violence and help seeking. And some of the content might be difficult. So we encourage you to take care of yourself in whatever way feels right. That might mean taking a break or stepping away or reaching out for support. If you wish to have support during this webinar, a list of supports and services is available via the link posted in the chat. A support person is also available for anonymous text-based assistance during this event. You can reach them at the number that will also be posted in the chat. It's 883-343-0186. With that, I am so very pleased to introduce and to be joined by Deepa Mattu, Pamela Cross, and Peter Jaffe, all of whom are members of the Domestic Violence Death Review Committee. I'm going to introduce them a little bit more as we get to their section. But just before I do that, I'm going to do a very, very brief intro of the DVDRC. So as many of you know, the Domestic Violence Death Review Committee in Ontario, it started in 2003. It is actually one of the longest standing DVDRCs in the country and in the world. This multidisciplinary committee reviews all homicides that involve the death of a person and/or his or her children committed by the person's partner or ex-partner from an intimate relationship. And based on these reviews, it makes recommendations to prevent further deaths. In June of 2022, the Office of the Chief Coroner issued a call for new members of the DVDRC, and there was a public process to identify suitable candidates. 15 members were appointed, some were new and some were continuing, along with 2 resource members. And these members represent Ontario's diverse communities and come from frontline services, academia, public safety, and the legal field. This webinar reflects the experiences and views of members serving on the DVDRC, but it does not necessarily represent the views of the Office of the Chief Coroner. One of the things we know from a review of DVDRC cases over 10 years is that domestic homicides are among the most predictable and preventable forms of homicide. Based on a review of 219 cases, we know that men are perpetrators in the vast majority of cases. Women are most frequently victims, and in 3/4 of the cases, there are 7 or more risk factors. We also know quite a bit about the recommendations and what they say. Again, we have summarized the 400 recommendations that have made in these cases, and they tend to fall into these 4 different categories. 1 for education and training, 1 for collaboration and coordination, recommendations about risk assessment, risk management, and safety planning, and those about policies, programs, and legislations. This version or this report from the DVDRC, which is the first from the newly formed committee, takes these recommendations a step farther by looking at how they might apply and be implemented with specific populations and specific contexts. And so with that, I will introduce our speakers for today, or our first speaker. Our first speaker is Deepa Mattu, who is a dedicated lawyer and intersectional feminist recognized for her commitment to advancing equity, anti-oppression, and anti-racism. Since 2019, Deepa has served as the executive director of the Barbara Schleifer Commemorative Clinic. And Deepa, I will hand it over to you to talk about the Chapter 5, Immigrant, Refugee, and Precarious Status Communities Experiencing Intimate Partner Homicide.
Thank you, Katrina, and thank you everyone who has joined us this afternoon. I will be speaking about Chapter 5, and as an opening, I wanted to start by this quote. Homicides with gender-based violence in the background are not isolated acts of violence. They are culmination of systemic failures and missed opportunities for intervention. DVDRC findings show that established risk factors like separation, history of abuse, intersect with structural inequities, amplifying vulnerability. For immigrant, refugee, and precarious status communities, immigration dependency, fear of deportation, language barriers, and socioeconomic marginalization creates compounded risks and obstructs pathways to safety. These deaths are preventable. Each case represents a call to action. As we discuss these cases, we do so with deep respect for the lives lost and the families forever changed. This is difficult work, so please take care of yourself as we move through it and engage as much as you can, thoughtfully and respectfully. Together, we honor those who are no longer with us and commit to building systems that protect and prevent. Immigrant and refugee women face higher gender-based violence risk than Canadian-born women due to intersecting vulnerabilities, which includes their status, but also racism, sexism, and economic precarity. Nearly 1 in 4 women in Canada are current or former newcomers, and GBV is a frequent experience during migration as well as settlement journey. Gender-based violence includes physical, sexual, psychological, financial, and systemic violence, often normalized in non-physical forms, which could be coercive control, threats of deportation, child apprehension. COVID-19 definitely amplified intimate partner violence risk for immigrant women, trapping them with abusers and limiting access to shelters and legal aid. Just to give you a context of precarious status in Canada, stats show us that there are 3.2 million non-permanent residents in Canada, which is 7.2% of the population. These people could be on work permits, students, asylum seekers. There are different stats talking about undocumented and non-status people. We say from the government, there is approximately 300,000 to 600,000, but the advocacy groups suggest that there might be close to 2.3 million precarious status people in this country. In 2024, there were 7,300 people deported, mostly rejected refugee claimants. Government aims to reduce temporary residents to 5% of the population by the end of 2028, it says, in some places, instead of 2026. But for 2025, the cap for the new arrival is 600,000 as compared to the 800,000 mark that we had in 2024. So broadly speaking, if you don't have them here, then the problems will be resolved, is the stance that a lot of policymakers are probably taking in this environment. So the diagram in front of you kind of talks about immigration status is a risk amplifier. Some of this I've already talked about, which is people fearing that they will be deported if they come forward and get in touch with any kind of safety enforcement agency. Language barriers is another big one. A lot of people who don't speak English as their first language, and or even if they speak English, but that's not their mother tongue and not language of choice, they face a lot of language barriers. in accessing services and resources, precarious economic conditions, isolation, where we know that isolation is a risk factor for everyone. But when it comes to refugee, immigrant, non-status populations, isolation means isolation from the community resources, but at times it is also isolation from their own communities on which they are dependent. Access to health. Many of you probably are already aware that we are headed into an environment where the access to health for refugee and migrant communities that we had gained over the years is now being scaled back all over again with recent changes in law. Access to justice, again, because the status of the people is fluid and changes with different applications at different times, depending on what status you are on or without status, you do not have the same level of access to justice available as it is available for people who have citizenship. And then the sponsorship dependency that I believe is the most understood experience of this continuum of challenges and systemic barriers for this particular community. Something that probably is important to note that immigration status as a challenge or an amplifier of risk doesn't really happen in isolation. It actually intersects with mental health. In many situations, it actually intersects with family law, cultural stigma, creating layered vulnerabilities. In my opinion, immigration status is not a side issue. It's one of the core risk factors for intimate partner homicide for this particular population. So now coming to the report, what did we see in the report? In the report, we saw that out of the 28 cases that were reviewed, 12 cases involved immigrant, refugee, or precarious status situation. 70% of all cases had 7+ risk factors, and common overlapping risks were immigration dependency, mental health and substance use, actual or pending separation, economic insecurity, language barriers. The overlapping risk factors create a compounded environment where intervention is harder and the potential for lethal violence escalates. This is why culturally responsive risk assessment tools and trauma-informed approaches are critical. So, as per the report, which we all probably are reviewing or have reviewed, here are some things that are worth noting. History of domestic violence was seen in 89% of the cases. Victim vulnerability was seen in 82% of the cases. Excessive alcohol and drug use by a person who caused death was seen in 61% of the cases. Perpetrator unemployed was found in 61% cases. Actual or pending separation was found in 61% cases. Sexual jealousy was found in 50% of the cases. Other mental health or psychiatric problems were found in 50%. Depression, professional or friends or family opinion was found in 46% of the cases. Living common law relationship was in 39% of the cases. And victims' intuitive sense of fear was found in 39% of the cases. So this slide kind of gives us 8 of the top 10 risk factors repeatedly across the 12 cases which were covered in Chapter 5. If you will look at these top factors and compare them to the overall result, which I presented in the previous slide, you will see that they are pretty overlapping. So what are we talking about? Again, we are talking about history of domestic violence. We're talking about victims' vulnerability. We are talking about excessive alcohol and drug use. We are talking about perpetrator unemployed, talking about actual pending separation in 6 cases, sexual jealousy in 2 cases, mental health problems in 4 cases, depression, living common law, and victims are in 2 cases, and victims' sense of fear in 3 cases. The point that I'm wanting to make here is that although there are unique vulnerabilities and risk factors that we need to be looking at, but we also need to understand when the system and the barriers in the system, which are intersectional in nature, are reviewed and recommendations are made based on that assessment, it doesn't necessarily just impact people from that particular community of intersectional experiences. I have sometimes said that intersectionality is for everyone, and I think this data kind of speaks to that. So, talking about complexity of the cases, and here is a trigger warning because I will be talking about the cases that are covered, where what we saw was a student who was here on international student status and was murdered by ex-partner, where fear of immigration consequences kept her silence from connecting. The case 3, which is also very tragic, was involving an immigrant family where the father was dependent for his status and killed his child and himself after losing custody. Each case demonstrated how immigration status intersects with mental health, family law, and cultural stigma, creating layered vulnerabilities that escalate lethality. If someone can help me move the slide. Thank you. So when we look at these cases from a focused lens, the picture becomes even more clearer for all of us. We see that in nearly 43% of the cases, we were looking at immigration and precarious status, but in 70% of all cases had 7 or more risk factors. That is DVDRC's benchmark for high lethality. Immigration status rarely stands alone. It intersects with other precarities, as well as family law disputes in many of these cases. These overlapping risks create an environment where intervention is harder, and in many cases, intervention leads to violence that sometimes can be lethal. I know that my colleague Pam will talk about this more in detail. Again, I cannot emphasize enough for the need of culturally responsive services. If we can go to the next slide, I will talk about the recommendations very quickly. I have a couple of slides talking about recommendation. One of them is about the cross-ministerial collaboration to address systemic barriers faced by immigrant and precarious status communities. Immigration and Labor Ministry must create secure pathways and multilingual outreach, secure pathways to status, Child protection and social services need specialized IPV units and trauma-informed training catered to the need of this particular population. Law enforcement and border services must adopt culturally responsive practices. Education institutions should provide mandatory IPV awareness for international students. And together, these actions create holistic safety net, one that can dismantle fear and hopefully create safety. So obviously, we want these recommendations to lead into preventing further deaths, identifying missed opportunities, promote systemic change, encourage collaboration, and foster cross-sector coordination, raise awareness, and create non-binding but influential change for the uh, for the enforcement agencies, which is not related to further victimization and criminalization, but rather influencing policy and program development with more safety in mind. Immigration status, particularly when precarious, can be um, significantly heighten an individual's vulnerability to abuse. Addressing IPV in immigrant, refugee, and precarious status communities cannot be understood through single lens. It is shaped by immigration policy, gender inequality, economic precarity, and cultural stigma, as well as institutional bias. That institutional bias is at the root of this intersectional systemic barrier experience. Addressing this requires holistic intersectional approach that centers the voices and needs of those most affected. With that, I'm open to the questions that people might have. Thank you so much.
Thank you so much, Deepa. I do have a couple of questions for you. One of the questions that is being asked and that I want to pose to you is, do you have recommendations for how the gender-based violence sector might better collaborate with either settlement services or other service providers for immigrant, refugee, and newcomer communities?
Absolutely. I think at the root of that cross collaboration, where we talk about working with culturally responsive lens, there is so much that gender-based violence sector can learn from settlement sector. And there is so many good best practices that gender-based violence sector uses that can be utilized by settlement sector. I think always about risk assessment and screening. And I believe that settlement sector can do so much more work in the screening area of screening for violence, because they meet people at various stages of their migration journey, and vice versa. Gender-based violence sector can learn so much about being culturally responsive, welcoming people in a space in a less professional but more grassroots, family-like environment where many people from immigrant, migrant, non-status communities feel a lot more comfortable in their interaction. A, a, a professional service can sometimes be a bit alienating for an immigrant woman who doesn't have language access. So creating that, a village-like response is what settlement sector does really well. So I think that cross collaboration boils down to learning from each other's practices and adapting our modality based on those practices.
Yeah, thank you so much. In the same line, because one of your answers makes me think about how one of the common recommendations is the need for, everybody to have some understanding of the major risk factors and warning signs. One of the other questions that came in, somebody commented that even when there is available language interpretation access, the interpreters are not necessarily qualified in the areas of either family law or law in general and family violence. And so that's another barrier. And our member asked, do you think a professional body might help in reducing some of these issues?
I mean, I work at Barber Schleifer Clinic, as all of you know, and we have a very extensive training module for our interpreters, which includes training in how to work in courts, how to work with various areas of law. There is a lot of training on cultural competency and trauma-informed practice. I cannot offer that everyone should work with our interpreters. That would be a little bit too complicated to offer with our capacity. But I definitely can offer that whichever interpretation service you work with, we will be very happy to share our resources on what that training looks like, because interpreters are also cultural brokers. They're also cultural informants, educators. And there is a need for us to better understand how to work with interpreters from that trauma-informed lens. A professional body absolutely is needed, but I think that professional body cannot necessarily be a professional body that exclusively works with this population. If we get a gender-based violence commissioner in this country, there should definitely be a person attached in that office which works for the systemic issues of the immigrant, non-status, and refugee populations.
Thank you so very much. I really appreciate this. Thank you for your presentation. I'm going to turn it over now, once again, to Pamela Cross, recognizing that some of the next questions are about court, and this is where we're going in terms of thinking about intersections with family law. Thank you again, Deepa.
And thank you, Katrina, for introducing me. Welcome, everybody, to this webinar. I'm very happy to see so many of you here today. I'm just briefly going to go back to something Katrina said when she was introducing the Domestic Violence Death Review Committee. Katrina, you talked about it being both an honor and a pleasure to serve on the DVDRC. I would have to say that it's an honor. I'm not sure that it's always a pleasure. It's very difficult work, as I'm sure any of you listening to this webinar can appreciate, because as Deepa has said, we dig deeply into the stories of families that have been forever changed because of intimate partner violence that has led to death. So I'm going to reserve the concept of it being a pleasure. One of the other things I'd like to say, again, in a general way, and I will get to what I'm supposed to talk about very soon, is that many of you will notice today, or perhaps you noticed when you attended the previous webinar in this series, or you might have become aware of this because you've already read our most recent report, there are a lot of similarities between the themes from the DVDRC recommendations, from inquest recommendations in Ontario, I think in particular about the CKW inquest held in 2022, but also similarities with inquests and inquiries held in other provinces, including the Mass Casualty Commission. So we're seeing many of the same kinds of themes running through these deaths, and that means there's also considerable overlap in the kinds of recommendations that all of these different entities are bringing forward. Often attention when we're talking about and thinking about responses to family violence focuses on the criminal law. As a society, we tend to think about guilt and consequences for those who have caused the harm, and criminal law kinds of protections for victims and survivors, things like peace bonds, bail conditions, jail sentences, and so on. But it's important to remember that, in fact, fewer than 40% of women who are subjected to family violence ever call the police, while virtually all of them, especially those with children, find themselves engaged with family law and often with family court. In other words, family law is critically important in situations of family violence. Of course, the purpose of this webinar is not to provide you with a Family Law 101 class, but I do need to say one thing very specific about the law, because we have folks attending this webinar from all across Canada. Family law is governed both federally and provincially and territorially, and that means the laws are not identical everywhere in Canada. The Divorce Act is the federal law, so it applies across the whole country, but it only applies to people who are married and who are seeking a divorce. Everyone else, and sometimes married people too, but we're not going to go too deeply into that, everyone else is governed by provincial and territorial statutes, and those vary somewhat from one jurisdiction to another. Because the work of Ontario's Domestic Violence Death Review Committee is to examine intimate partner violence homicides in Ontario, we're looking at the impacts of the Divorce Act, which would be the same for people everywhere in the country, the Family Law Act, and the Children's Law Reform Act, which are specific to Ontario. Fortunately for us in Ontario, all of these pieces of legislation align very closely. But if you're from another part of Canada, your statutes may not do so. It's my experience supporting survivors of IPV who are involved with family law, often family court, that too many of them continue to encounter laws, processes, and professionals who lack a deep and nuanced understanding of family violence in laws and in courtrooms. And that leaves those survivors vulnerable to ongoing abuse, including lethal violence. Having said that, the 2021 changes to the Divorce Act and some provincial legislation are definitely moving us in the right direction by providing a comprehensive definition of family violence and making consideration of it mandatory when courts are making child-related decisions. That doesn't necessarily improve the situation of a woman who does not have children or whose children are adults and who is turning to family law and family court to resolve other issues as the result of leaving an abusive partner. A tech question: has the static problem cleared up now that I've moved my mic? Can somebody just say yes or no?
Yes.
Okay, great. There are a number of current challenges, many of which surfaced as we reviewed the family law-related cases in the last report for the Domestic Violence Death Review Committee. These are ranked in the order of importance in my perspective, from my perspective. So others might rank them in a different order. Other people might take some things off this list and put other things on. But I truly, truly believe that the biggest, or at least one of the biggest challenges that we're dealing with right now is the lack of adequate education about intimate partner violence and about family violence for both lawyers and judges. Even though there is some legislation at both the federal and provincial levels with respect to judicial education, it's not enough because it's not mandatory and very importantly, it does not require judicial counsels to work with community-based experts. So folks like those of us you're hearing from today and many of you who are here attending this webinar as well. As a result of that lack of adequate education, ongoing myths and stereotypes continue to influence outcomes in family court. Obviously, this afternoon, we don't have time to discuss all of these, but one that I think is especially prominent in the cases we review at the DVDRC is the myth that violence ends at the time of separation. In fact, this is when women are at the greatest risk of increased abuse, including lethal violence. And as you saw from Deepa's slides, it's one of consistently, year after year after year, it ranks as one of the top 3 or 4 risk factors for lethality. Imminent separation, the abuser believes she's leaving, perhaps he's picked up a phone message from a lawyer, he's overheard something, he's snooped his way into her emails, so she may not even have made a final decision yet, but in his mind, she's going to leave him, or there's an actual separation. And we know, particularly with current economic situation, many people remain living under the same roof even after they've separated, which creates a still higher level of risk. Lawyers, judges, laws, court processes, and women themselves consistently underestimate this risk. Of course, for many women, this is an incredibly important moment. They've made the decision to leave, and the last thing they want to think about is that they may be, at least in the short term, increasing the risk of lethal violence. Third and serious current challenge is the lack of legal representation coupled with legal bullying. In some situations, reasons for this are somewhat different in different parts of the country, but we know that more than 50% of people generally who are involved in family court do not have legal representation. Some of that is because of low financial eligibility criteria ceilings, so that people who couldn't possibly afford to pay for a lawyer are considered too rich to be able to receive a legal aid certificate. But one reality that we're dealing with in Ontario, and I'm sure you folks from other parts of the country are dealing with it as well, is that women are able to get permission, a certificate it's called in Ontario, to have legal aid, pay for their legal costs, but they can't find a lawyer who will do the work. So that lack of legal representation, especially if the abuser is also unrepresented, can lead to legal bullying, which in turn leads to women accepting poorer outcomes than they have a legal right to, or in some cases, returning to the abuser. A fourth challenge is that many women underestimate the risk of ongoing abuse, including lethality. I'm just going to say a couple of words about Bill C-223, because I'm sure many of you are aware of it and have questions or comments to make about it. I have a question, which is, can that bill address any, some, or all of these challenges that I've proposed? It's a private member's bill. It's likely to pass second reading, which means it will go at the federal level to the Justice and Human Rights Committee for further discussion and hearings. And I would urge anybody who has been interested in this area to see if you can be invited to make submissions to that hearing. It certainly has some strong components, including a proposal to add a list of myths and stereotypes about IPV to the best interest of the child test provisions of the Divorce Act. It also attempts to deal with the problem of the misuse of parental alienation allegations that are made by many abusive men. My own opinion is that this is a weak part of the bill that doesn't, in my opinion, again, necessarily get it right, and could, in fact, make things more difficult for survivors. So something maybe for another webinar to dig into in proper depth. Now let's look specifically at the findings from the Domestic Violence Death Review Committee, which went to cases we looked at where there was some kind of family law component. We know that women and children continue to die after separation. And as I've already said, actual or pending separation is the third highest risk factor for lethality. However, the family law focus is very much one on friendly parenting, putting the past behind, moving forward, which indicates a real lack of understanding about this very high risk time that happens during and post-separation. We also know that trauma interferes with the survivor's ability to function well in family court proceedings, and that the lack of legal representation, a lack of financial resources, leads too many women to settle for unsafe outcomes and to try to manage their family law cases themselves. Women may enter into mediation even though they're afraid of their former partner. They may accept shared parenting or shared decision-making outcomes because they can't afford to keep the case going. We looked at least one case where the victim, the mother, supervised the abuser's time with the children, and it was during one of those visits that he killed her. We looked at cases where it was the victim of the abuse who managed the exchanges of children without any third-party supervision, again, increasing the risk of harm. Agreeing, and I put that word in quotation marks, to spend time with the abuser in exchange for receiving child or spousal support. So we see all of these kind of self-help measures that women take when they haven't been able to get proper legal representation to support them through their family court case. In terms of actual recommendations, we reviewed 7 cases during this period of time where there was an intersection with family law. But I want to make a point here. There were other cases with children where there was no family law case, and we couldn't always figure out what the reason for that was. Was there just not a case that had been started yet? Was this not information that was made available to us? There were a lot more cases that involved children where we would have expected to see some family law involvement, and we didn't. But that doesn't mean there wasn't any, or it also doesn't mean that that woman wasn't engaging in the kind of self-help strategies that I just talked about because she couldn't afford to get a lawyer or she didn't qualify for legal aid assistance. And also, if you think back to Deepa's case 3, there was a family law situation there as well, but that case got identified as belonging in her chapter because there were more elements that related to the fact of the family's immigration status and newness in Canada that we wanted to explore. So this number of 7 cases isn't a sort of absolute hard number that there were only 7 cases with family law implications. And certainly the issue of whether being involved in a family law proceeding or not being involved in a family law proceeding plays a role in the homicide is something that I think we need to look at further as we continue to examine these cases. We made a number of recommendations. I'm only going to talk about one bundle of them this afternoon because now that the report is out, you can all go and read it and look at the other recommendations. And the recommendations I'm looking at are consistent with what I identified as the biggest challenge, that being education and training. We made recommendations in 3 areas. First, judicial education. We made a recommendation to the National Judicial Institute, which holds most of the responsibility for educating judges, that there be a comprehensive educational program for family court judges to enhance their understanding of family violence dynamics and effective legal approaches, and that program be developed, reviewed, and regularly updated with input from community groups and survivors. The second education-related bundle of recommendations relate to training for family court professionals, lawyers, law students. This needs to be mandatory, and it needs to include discussion about the importance of mandatory standardized screening. We have some great screening tools for lawyers to use. In particular, I would promote the HELP toolkit developed by the federal government. But there's no requirement that lawyers use it. So some do and some don't. We need to have mandatory standardized screening. And the third category of recommendations in this area deal with public education. We need a public that is able to actually and accurately identify risk factors for lethality, post-separation abuse, and coercive control. We look at a lot of cases where people who knew the family will say, we knew things weren't right, we were worried about her, but we certainly never thought it was going to kill her. So public education to help people understand that better. Also to help people understand what family law can and cannot offer to a family in this situation. And also, and finally from me, before we open it up for questions, we'd like that public education to help the public be aware of any programs. In Ontario, we have the Family Court Support Worker Program. Any of those kinds of programs that can provide assistance to a survivor who's dealing with family law. So Katrina, I'm going to leave it there and turn it back over to you for questions.
Yeah, thank you so much. Pull your mic away again. Perfect. Thank you. I have a couple of questions. There are people that I think what we want to dig in most at this point to this is the idea of perpetrators using the family court system as a tool for continued abuse. So I wonder, can you give some examples of what legal bullying or continued use of the court looks like in practice? And we have a question. If you're comfortable sharing, would you have advice to survivors who are facing ongoing manipulation, particularly when it's framed in these legal terms by their abuser's lawyer?
Well, the first part of the question is a lot easier to answer than the second. There are so many ways that an abuser can interfere with what should be happening in a family law or family court process. especially in smaller communities or even in large communities if the family is part of a small cultural or linguistic community. That abuser can consult with every lawyer in the community, thus meaning that none of those lawyers can act for the former partner. So if he gets out the door first, even if he doesn't hire any of those lawyers, once he's consulted with them, they are considered to be in a professional conflict and cannot represent the other party. It's a very, very common form of legal bullying. Delaying the process, asking for extension after extension, coming back to court over really minor issues or issues that have already been decided upon, holding up things like getting a hold of his tax returns and providing them, being less than honest in his completion of the financial statement, claiming that she's alienating the children from him. I mean, those are just a handful of ways that an abuser who's very determined to try to keep the upper hand can use the family law system as a weapon in his ongoing abuse. And they can be successful because in many instances, cases are not seen by the same judge every time. And so it's difficult for a judge to see that pattern of behavior, but also because family court is focused on understanding that families are dynamic entities. Things change. There's a need to reassess and reevaluate whether a decision made 6 months ago is still an appropriate one now. That's all great. But when the abuser just keeps basically making stuff up in order to wear his former partner down emotionally, run her through all the money that she has for a lawyer, that's when it becomes legal bullying. What a woman should do in that situation, that's a hard question to answer because it really depends on where she lives and how many resources and services are available to her. There are ways to respond to legal bullying. There are legal steps that a judge can take to shut a bully down. Most unrepresented women would not be aware of what those possibilities are. So in Ontario, I think women are relatively fortunate because they can turn to their family court support worker or they can turn to a resource like the Luke's Place Legal Clinic, which is free. It's available online. The services of the Barbara Schleifer Clinic, many of which are available across the province. But I certainly can't speak for what's available to women right across the country.
Yeah, thank you. And I guess for my last question, I'll kind of build on that a little bit because you talked about some of the resources and services that have developed within Ontario. You also mentioned the change to the Divorce Act. Do you see, or maybe I'll say, what do you see as signs of positive change, if any, in terms of what's happening in family court?
I think the changes to the Divorce Act are important and are positive. So for people who don't know what they are, there is now an 11-factor test that judges must consider when they're making any decision related to children. One of those factors is family violence, and there is quite a nuanced and comprehensive definition of family violence included in the legislation that talks about non-physical kinds of abuse and talks about abuse that does not result in criminal charges being laid. So I think that Divorce Act is really critical in Ontario. Our legislation mirrors it as it does in many, in fact, I believe now most provinces, but not the territories yet. We still have a long way to go because we need more judicial education, but I think that's a hugely important step in the right direction.
Thank you very much. I really, really appreciate this. I'm going to turn it over now to our final chapter and introduce Dr. Peter Jaffe. I'm so glad to welcome Peter to this webinar. Peter is one of the DVDRC's founding members, and so, has a wealth of information about this and has been serving as a mentor or an advisory member of the committee. He is also the Emeritus Director of the Center for Research and Education on Violence Against Women and Children. I'm pleased to, and has done sort of training of judges and other people within the court systems for many years. He's going to be presenting on Chapter 2, which is thinking about children in the aftermath of intimate partner homicide. Peter, over to you.
Thank you, Katrina. My focus is going to be on children and how often children are actually the forgotten victims of intimate partner violence from what they see and what they hear, and often the consequences that they suffer themselves. There's often, from our work on the Death Review Committee, and as Katrina said, I've probably been involved either directly or indirectly reviewing over 600 domestic homicides, and over half of them involve children directly as witnesses to the homicide or the aftermath, or children being the victims of homicide themselves. We have talked about trigger warnings. Pam mentioned the impact of this work, and Katrina mentioned it, but I just want to mention something that goes beyond our suffering of post-traumatic stress disorder. And I'm conscious that as we present, our participants from across Canada and elsewhere include professionals who've been involved in cases and who have lost clients to homicides or near homicides. There's also surviving family members who may be listening in. And one of the things that I keep thinking about from all the things that I have seen, it's not just the trauma, but it's moral injury. And by moral injury is what happens to us when systems and institutions fall short and we witness harm to children and family members in the context of intimate partner violence. So it's how we're impacted in terms of our own sense of safety, security, how the world is supposed to work, and believing in systems, and then seeing systems that may fall short. And again, our work is not to shame or blame, but more to talk about this more openly, because part of the healing is acknowledgement of the shortcomings and a redoubling of our efforts to do better, acceptance of our shortcomings, and being able to share what we see, what we witness, and joining to do a better job. Because our work at the end of the day is, we can't bring back to life those who we have lost, but we can be sure that we're going to prevent tragedies and similar circumstances in the future. When we think about children and how they're affected by intimate partner violence, they're affected by the exposure to the violence. They're affected in extreme cases by exposure to domestic homicide. And they also may lose their life by being part of an intimate partner violence dynamic and what may happen to them. When we talk about exposure to domestic violence, one of the good things that Pam referred to is how our Divorce Act, and in Ontario, the Children's Law Reform Act, and some other provinces, how the laws have changed, because now in the Divorce Act and in some provincial legislation, you don't have to prove that children actually experienced domestic violence directly. They don't have to be an eyewitness. They can see it, they can hear it, they can see the aftermath, the injuries, the distress in a parent. They can hear about it from someone else. So all these are forms of exposure to domestic violence, intimate partner violence, that can adversely affect children over a lifespan. And again, it's so important to emphasize this now exists in law in Canada, and it often is overlooked or ignored. And actually, our Supreme Court has a recent decision which talks about children's exposure to intimate partner violence as being fundamental to understanding the harm to children, and goes to the heart of a parent's inability to properly look after children given what they're doing to their partner. In terms of recognizing the harm to children, there's been all kinds of research about how domestic violence affects children at every age and stage of development in terms of children's trauma, uh, the impact on their emotional, behavioral, social development. It's important to note that exposure to domestic violence is the number one reason why people call child protection agencies across Canada. 1 in 3 substantiated case of child abuse involve children age 3 or less. So you can think about the early impact. A quarter of children became physically involved as the abusive incident was occurring. And the long-term impact may result in young people who witness violence and then become the abuser in relationships. And one of the issues that Pam often reminds me about is sometimes those children grow up to be adult children who may abuse their mother from the things they've witnessed for many years. They also may become protective depending on a number of other circumstances, but we have to be aware of the long-term harm as well. You'll have a copy of these slides, and these slides have references where you can look at many of these issues in greater detail beyond what I can present. But to summarize research of almost 50 years, a lot of which started in London, Ontario, Canada, is looking at the impact of domestic violence on children, leading to greater use of medical services, impacts long-term poverty, young people more likely to accept domestic violence, blame themselves for the violence, trauma, hypervigilance, stress reactions, poor academic outcomes, especially with exposure and direct abuse as well. Many of you will be familiar with adverse childhood experiences and the long-term impacts. There's reference to a website you can look at in detail for those of you not familiar with the research. But often we're looking at multiple adversities. It's not just exposure to intimate partner violence. It's also multiple separations, poverties, parents with addiction and mental health issues, and the long-term consequences for children going into adulthood is profound in terms of emotional harm, physical and mental health, addiction issues, and poor education and occupational outcomes. We can't overlook children who become homicide victims, and this is another very painful topic to even think about. But we have to talk about it because it's a reality for many children. Many Canadians and many of you from other parts of the world are shocked to know that children are most in danger of their own parents. Myrna Dawson did an extensive review just looking at 50 years of data in Canada, and she looked at major trends, looking at 1,600 kids under the age of 18 who were killed by parents. In the context of intimate partner violence, it's important to note that fathers are more likely to be motivated in to kill children by jealousy, revenge, retaliation for the mother leaving the relationship, often in the context of prior domestic homicide. In our experience at the Ontario Domestic Violence Death Review Committee, going back over several decades, and also looking at reports across US jurisdictions, children are usually killed in 3 contexts: indirectly, as a result of attempting to protect a parent during a violent episode; alternatively, as part of an overall murder-suicide plan by a parent who decides to kill the entire family. And I should say the research that Myrna Dawson and our colleagues at Western have done, of the Familicide, where the whole family is killed, it's 96% men, so this is not a gender neutral issue. And children who are killed as an act of revenge against the partner who decided to end the relationship, or some perceived betrayal. So I mention these issues because protecting children living with domestic violence is not just psychological harm, it's often a matter of life and death. And in the research looking at the US, Canada, the UK, New Zealand, Australia, 10 to 20% of domestic homicide victims are children. And we're often hesitant to address these issues. There are common risk factors known before the homicide: separation, prior history, depression, threats to children, stalking, harassing behavior. These risks we see consistently. These homicides are often predictable and preventable. The research suggests that when adults are in danger of domestic homicide, so are children. And there's risk not only of death, but irreversible trauma. And by trauma, I'm going to refer to living with the aftermath of intimate partner homicide. When we think about domestic homicide, over half the cases involve children who are at the scene. Often I'll read media reports that say the children at the scene were unharmed. And yes, they were unharmed physically. They didn't lose their lives, but they have been forever changed in terms of the horrific scenes that they have been exposed to. Many are eyewitnesses to horrific tragedy and trauma. They may lose one or both parents, one parent to a homicide, the other parent to life incarcerated. Some may be caught in custody disputes between the maternal and the paternal family systems. I've been involved in cases where the custody dispute begins shortly after the death, when the maternal and paternal families fighting for the children, not only the children, but also they may have conflicting stories or histories about what actually happened. In Ontario, our experiences, many of these children are the ones who call 911. They find their mother injured or killed, or they're at the scene when the police arrive and are exposed to incredible things that no one should ever see or be part of. There's more detailed studies in the US that detail the number of children who actually witness the death, discover the body, and also the number of children who witness multiple violent events prior to the homicide. If you look at the impact, I'm not going to go through this whole slide other than to say this is not a new area of research. And in my reference section, there's extensive research being done in the state of Arizona looking at this issue, and in Australia. And this is one reference. And the important point when you're thinking about providing services for children that may have been exposed to domestic homicide, you think about all the trauma they experienced before, the prior domestic violence, the family stressors, their actual exposure at the event, what happens after in terms of the remaining caregivers' distress, conflict between family members, contact with the perpetrator, perpetrators in jail asking for contact with their children. A big issue for us in our recommendations is lack of appropriate mental health care and the long-term difficulties in terms of trauma, social problems, the long-term health consequences, academic problems. So these are all significant issues. The major recommendations from our committee, and I hope you'll access the report that we will provide to you. You can find online at the Office of the Chief Coroner of Ontario. The major issues are around training across professional groups on the impact of intimate partner violence and intimate partner homicide. Expand funding to adequately fund ongoing counseling. This is not short-term counseling. This is not a quick response. This is not 3 or 4 sessions and you're done. This is obviously ongoing counseling, and often children with this experience and their relatives who may be advocating for them have difficulty accessing long-term counseling. Obviously, the Children's Aid Society, which in Ontario is our term for our child protection services, need better resources to support these children. And even if they don't have the resources to support these children, they need to remain involved until services are properly in place, or those children continue to be in need of protection and support. As Pam said, ongoing training for judges and lawyers around these issues, especially around parenting time and parenting decision making to keep children safe, and also the need for ongoing research looking at the lived experiences of these children. And the slides I provided in the reference have links to major websites that I'd ask you to look at your leisure, which include young people speaking out and adult survivors of childhood violence and homicide speaking out about the long-term needs. These are issues that are beyond any one agency. When we're talking about child and adult victim safety, we're talking about corrections, courts, healthcare, child protection, police, victim advocates. So obviously multiple sectors have to be involved. One of the things that I'll mention just in closing before we take questions is talking about the fact that many of our recommendations are not rocket science. Often we have said the same things over and over and over again. And one of my conclusions after many years on the Death Review Committee is the key is not so much what we say or what we recommend, but the key is in implementation, making sure that the things that have been recommended to save lives actually get implemented, and not implemented in one pilot project somewhere, but implemented on a consistent and a comprehensive basis. So it doesn't matter whether you live in Cornwall or Churchill or Calgary, these services are available and provided. And obviously our focus with our report is Ontario, making sure they're available across the province. And then beyond implementation, I think is the important issue of auditing to make sure when things are recommended and making sure they're implemented, but finding some accountability mechanism where on an annual basis, there's some report like the Auditor General's report where we can say, this was recommended, what are we doing? What's our progress? What's our time frame? What do we need to do? Because we don't fall short of ideas. We never fall short of good recommendations. We fall short of implementation and the ongoing accountability to make sure those things take place. As I mentioned, references available. I'd ask you to really look at these major websites, one in Arizona and one in Australia that details some of this ongoing work, which I hope we can adopt in Ontario and Canada to do similar work. I will leave my comments at that, and I welcome the questions from participants.
Yeah. Thanks so much, Peter. I really appreciated that presentation. I know that you've reviewed many, many cases. I know when I am reading those cases, and as you note so often, there are children they often see, hear, know about, and find their parent who's been killed, and it is always so difficult to be thinking about those kids and their experiences. I also think about an opportunity I had at one point where children who had lost a parent as a result of domestic homicide were able to come together as adults and speak to their experiences, including some of the ones that you talked about around battles in court and lack of funding or lack of therapists that understood that. And so it really made me think about the value of connecting and having some expertise in that area, which they had, but sharing that for other families. Do you know if in Arizona or in Australia they've set up sort of specific like accessible services? So because somebody really does need to come in with some knowledge and understanding and help to kind of direct what happens afterwards to make sure that the children's needs are met, not only then, but after.
Yes, in Arizona, they have specialized services, so they have a whole group dedicated to this, and they promote their services and awareness. And the same thing in Australia. If you look at the link, there's people can clearly connect and share issues. I think, you know, in Ontario, and I think in the rest of Canada, I can probably speak freely about my experiences that it tends to be more hit and miss. It tends to be each person. I know in our death review committee, we've had reports like from grandparents saying, where do I get help for my grandson or my granddaughter? This is what they've lived with. And it's all case by case. So you have to, you know, go to your family doctor, and your family doctor will look for, you know, child psychiatrist, psychologist, or social worker, but it's very much hit and miss. But that doesn't work very well because you're talking about extreme trauma, and you want somebody experienced, you know, with this level of distress uh, in children, and also it's both the children, also the family system that's coping. So I think we have to do a better job identifying centralized services, even if that information was available to police and crown attorneys who deal with these cases. There has to be a network that's more readily accessible, because generally my view, and I'm generalizing from my experience over 20 years, most of these children do not get the services that they need. And sometimes one of the big problems is the adults dealing with the aftermath of this tragedy are so overwhelmed with their own sense of loss and grief that they don't really want to talk about this issue anymore. And they certainly, they do talk about it, they don't want to talk about it to the children because they're
Mhm.
worried they're going to distress the children. But in fact, these issues have to be addressed with children at every age and stage of development. Um, so it's so important. We have to recognize that children may not approach anyone because if the adults aren't approaching them, the children think this is a taboo topic. I shouldn't talk about this because the adults in my life are too distressed. So many end up in a journey of discovery when they're later in adolescence or early adult years. So it's so important we develop better systems and connections.
You know, Peter, that reminds me of some work that I was just reading by Simone Lapierre about children living with in families where there's family violence. And, you know, one of the ways kids can have some agency, and they often have agency, are trying to make everybody safe and make everybody feel better. And so findings around children, you know, trying to protect their abused parent by not showing or expressing the amount of distress that they're feeling because they're worried about burdening their abused parent. So it makes me think that same pattern applying in all situations.
Yes. Actually, it's interesting. There was a book written almost 40 years ago, Children Who See and Hear Too Much, by Betsy McAllister Groves in the Boston area. And her whole book was really about all the things that children live with and never want to tell anyone because they don't think adults can handle the truth. They don't
Mm,
they don't think adults can manage. Either they're, you know, not to stereotype, they might feel their dad is too angry to hear this. They might feel their mom is too distressed or upset. This is too painful. And and often they tell no one. We did a study going back many years where we'd asked children living with domestic violence. We interviewed over 250 children, and most of them had told no one. And actually, our research study was the first place where they actually shared that they'd never told a teacher or a counselor. Um, so we really have to obviously raise public awareness about this and open the doors, both with obviously friends, neighbors, families, but also teachers, people on the front line
Yeah.
who need to be open to this information and provide support.
Thank you so much, Peter. I really appreciate it. Thank you also to Deepa and to Pamela for your presentations. I'd also like to thank the ASL interpreters, Marcia and Mike, and the French language interpreters, Wendy and Geneviève. I'd like to give a special thank you to the Learning Network and Knowledge Hub and Family Violence Family Law teams for their behind-the-scenes coordination. I just have a couple other small things. On behalf of the Learning Network and the Knowledge Hub, we look forward to welcoming you to future webinars and events. Our next webinar is on designing trauma and violence-informed policies, training, and response plans to address intimate partner violence at work, which is one of the recommendations of the DVDRC. And so, I take this such important point about how do we make these recommendations into action. And so this webinar will take place on December 9th from 1 to 2:30 Eastern Time and will be presented by Rita Sawatsky. So you can register for this webinar through the link in the chat. We would also like to invite you to the Learning Network's 2026 Virtual Forum, which is going to bring together practitioners, researchers, and advocates to explore how artificial intelligence is both contributing to gender-based violence and reshaping practice across the GBV and allied sectors. And I'm very interested in some of the conversations. I certainly have been in some interesting conversations about uses and misuses of AI and how this can be part of coercive control. So you can register for the virtual forum through the link in the chat. As well, if you would like to share your insights, or we ask that you might share your insights on how AI is showing up across gender-based violence prevention, response, and service delivery, including your own awareness and experience addressing AI-enabled forms of harm. So your insights are actually going to help us inform the Learning Network Virtual Forum, and you can learn more about that survey and access the survey through the link in the chat. Once again, thank you so much for joining us today, and we will look forward to welcoming you at the next webinar. Bye.